really awesome. So this is a roadshow that we are going across the country explaining and doing a bit of an in-depth talk on the industry trends that are impacting claims. So while more people are joining us, I'm going to then just jump in and start with a little bit of a Connect demo, and then I'll be handing you over to Willem, our actuary, who'll be presenting. So firstly, I am Kerry Bardnos, the Key Account Manager at Munro. Willem will do all his introductions, and I'm going to then start straight with my presentation. So while I'm busy loading Connect, if you haven't seen this before, you should be able to see a little scan QR code in my image over here. Please grab your phone and scan it. What that will then be doing is it will take you to the Connect logon page, where you would then be able to, if you've got a Connect account, log in. Alternatively, you would then be able to request a Connect account. So I'm just going to wait a second or two for you guys to do that. So you're going to have to see my face, and just above my face will be a logo that you would then be able to scan. So I'm just going to give you a second or two to do that. I didn't count. I hope that was a second or two now. All right. So what is Connect? I'm hoping you guys are sitting there going, if you haven't seen it, what is she going on about? So Connect is a Munro portal that allows you 24-hour access to your Munro account. So it's not only your Munro account as in financial side of things, but it allows for you to be able to instruct Munro, request amendments, see what's happening with your matter. The progress status will be there. The most favorite of my features is the contingency calculator, which I'll touch on just now. And then you are able to also view your firm's financials. So this is a nice way, the starting screen. So if you kind of have a certain place that you really want to be, the tiles can then direct you there. Alternatively, there are options on the left-hand side where you would then be able to go and click through to the different menu options. What I'm going to do is I'm going to go and click on the matters option on the left-hand side. Because everybody's attorneys here, you guys are going to be instructing us a lot and requesting amendments. So this is more relevant for everybody that's attending the session today. So once it loads, what's quite nice about this, it will show you a search bar. So you can then decide to search for a matter if you wish. Alternatively, there is a list of matters that you would then be able to go through and find what is appropriate to what you're looking for, wanting to do. So as you saw at the top right, here's an instruction module. So if you would choose to use Connect, you would then not send us an email with an instruction. So you would then need to decide on what you would like to do. So you could either send us an email instruction or use Connect. So what I've heard a lot from clients that uses Connect, they actually prefer to instruct us through Connect. It's a lot quicker and easier. So you would then be able to click on this plus button and then complete the 3 easy steps over there. Then if you guys want to request an amendment, so either getting a report updated or you've got a new IP report and you need to get it amended, you would then be able to go and select one of these icons right next to the matter that you are looking at. So you would either search for the matter, find it in the list, and click on the amendment button. If you wish to download the report, so maybe it's somewhere in your inbox, you don't want to search for it and you're like, oh, how am I going to get this quickly? There is a download button over here that you would then be able to use. So I'm going to jump straight into my favorite feature, the contingency calculator. So what's really nice about this contingency calculator is it's designed for loss of earnings matters and matters that have been delivered within the 3 months. So if the matter is older than 3 months, you will then notice that this icon will be different next to that particular matter. You would then need to use the amendment section. If it is within the 3 months, you would then see a percentage icon and you would be able to go and play. And the reason why I say play with the contingencies is this system allows for you to go and try different contingencies as many times as you want free of charge. And the beauty of it, it does not adjust your original report. Your original report will stay as is. This will just create an addendum for you that you would then be able to serve in conjunction with your original report. So what I am going to do is I'm going to quickly do a demo on that, just because it's my favorite feature. So if it's a little black eyeball, it means that this matter isn't compatible. So it could be a loss of support matter, or a different type of matter, or more complex, therefore it wouldn't be compatible. If it's got a little red eye, I'm just going to quickly show you over here. It means that these reports have expired. So it means that it's gone over the 3 months. You can't go and change the contingency. So what you're actually going to be wanting to look for is the percentage sign. So I'm going to click on this first one over here, click on my percentage, and it's going to load my contingency calculator. So I'm sure you guys are all sitting there going, is this better than an old school calculator? And the answer is yes. So the reason for that is you don't have to go and type in all the amounts and with the zeros and make a mistake there. It's going to populate the screen where you are just going to type in the percentages that you wish to apply. And then it will then deliver that report for you. So I'm just going to give it a second to load. Perfect. Here we go. So here is the screen that's going to pop up. So everything I've told you, I've gone through everything at the top there for you. There is a nice video that you wish to watch, you can. It's going to now load my original report for me. So if I scroll down over here, I can then see and get myself familiar again with this particular report. So if I look at this report, I can see some contingencies have actually been applied. So we want to go and apply different contingencies. We're going to click change contingencies on the right over here. And this is the part that Willem cringes when I start. So being an actuary, he's great at numbers. So when I start playing here, he's like, what are you doing? But this is the beauty of this calculator, is that you're not going to break anything. You can try different percentages. So here we can see a 15 and a 40% was applied. So we might want to say, we want to remove the contingencies and see what the loss is without any contingencies. I've taken out all the contingencies. This is what my current loss is. When I say update contingency, it's now going to then display it on the screen for me. So you will then see that this amount is going to change shortly. So there we go. Can you see that the loss has then changed? If this is something that you would like, you go, oh, I'd like to compare, a report without the contingencies with different contingencies, you would then say print reports, and this will then store it in the archives for you. So after 3 months, this report will be available for you to go and peruse again or to save and file if you need to. So once I click on print report, it's busy generating the report for us. And while it's busy doing this, I just want to explain something really cool. A client phoned us this the other day and was super impressed. She was standing at court or in court, and the judge was saying to her, listen, can you apply the following contingencies? And I can't remember what they were, but I think they were like higher than normal contingencies. She's like, yes, but then we have to stand on the matter, and she doesn't really want to, prolong this matter any longer. So she remembered me giving her this demo, and she said, Judge, give me a second. She logged onto a computer, loaded this calculator, said what contingencies, loaded them, said, how do you want it served? She did exactly what I'm doing right now, sent it to the judge, and he was happy, and they settled the matter. So it's really, really cool that you don't only have to use this in your office. You can use this in court, settlements. If you're sitting at a settlement drive, you have a number of matters in front of you. You don't need the actuary next to you. You can actually do it straight away. And the best part of it, it takes into consideration your cap matters. So if your matter's capped, you don't have to now try and figure it out or phone the actuary. Come onto the Connect portal and there it is. So yeah, you can see it says addendum contingency report. If I scroll down, it's now taken out. It says no contingencies. And then this is my new loss. And then and the signatures are here. So you don't have to phone the actuaries to get it signed. That's done all automatically for you guys. Then you can print or save it if you wish. But what I'm going to do is I'm going to go back and I'm just going to do one last one, and then I'm going to be handing over to Willem. So loading up again my calculator on the same matter. I want to now change this to 17% and then this to maybe a 35%. You'll then notice a warning to say, these contingencies are higher than normal. Would you like to proceed? You can, because we know RAF sometimes does apply higher than normal contingencies. I'm happy, say update. And again, this is then going to update on the screen for you. So once it's updated, you want to then click on print report to save it into the archiving so that you can then print the different options and then compare them later. I'm just going to wait for that to load quick so that I can show you how quickly it is it updates. There we go. And then this is your next addendum report. So that is my personally favorite feature of Connect. As I said to you, you are able to view your firm's financials also through this Connect portal. There is a new feature coming as requesting affidavits. So look out for that launching in the next couple of weeks so that you can then request your affidavits through the Connect portal. No longer then would have to email us. You would then use Connect for most of the things. If there is anything you want to know about Connect, please pop your name in the chat and then we will get back to you after the demo to assist you guys.
Good, everybody. Can you hear me? Okay, great. So we want to focus a bit today on industry trends that's impacting claims. And before I get into that, Kerry did a brief introduction of herself. I think as most of you know, I'm Willem Boshoff, actuary at Munro Forensic Actuaries. Did my fair share of studies at the University of Pretoria, BCom degree, and then the long slog to become a qualified actuary to have that designation FASA. It's always entertaining when somebody asks me what I do and I say I'm an actuary. They think I want to sell them insurance. But yeah, we're here today to talk about what's happening in the damages space and some key issues that we've been encountering that we think will be valuable for you to take cognizant of and also perhaps discuss some of those issues. Just very briefly, a high-level overview of the damages industry. Our presentation today is going to really focus on the road accident fund. There's, of course, other damages matters to which these issues will apply as well, but the bulk of our work we do in the road accident fund, and that's where we see most of the issues. It's a sizable industry, and I think especially something like the RAF is enormous in the context of South Africa, and also the public interest around the RAF is massive. Because every single time we get into a car and we fill in petrol, or if we buy anything that's been transported by a truck, we all contribute to the road accident fund, and it plays an important social role as well. Not to mention that that's the way most of us earn our bread and butter. In terms of the damages industry, typically the key role that an actuary plays is that of calculator. So we get given a lot of information and we calculate the loss. But what we also like to do, and that's in terms of the wider discipline, is we monitor trends. And to quote Sherlock Holmes, it's data, 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 my dear Watson. And we assess and manage risk. And with that in mind, we hope to add more value to our clients by assessing data, by assessing trends that we're seeing and trying to make sense of it, and then share our findings with yourselves. We actively monitor judgments, as I'm sure most of you do in any case, but obviously judgments also has a sizable impact on the work that we do. So some of the trends we're seeing that's emerging currently, and it really relates to the judiciary, and to a large extent due to the fact that the road accident fund is largely absent as a defendant in most cases that go to trial, is that the judges are certainly taking a more proactive role. And I'm not here to discuss the merits from a legal perspective. I think there's many opinions around that, but we're simply observing what's happening. And judges are scrutinizing cases in more detail. At least the judgments we're seeing certainly indicate that judges are cognizant of the fact that the road accident fund is absent and to some extent stepping into the defendant's shoes. And we're picking up certain issues that's being identified by judges. And some of these are problematic from the perspective of the plaintiff. We are seeing cases where claims are being dismissed, claims are massively reduced, or very high contingencies is being applied to claims or uninjured earnings, and thereby reducing the claims. So our aim is to really just share our findings, to stimulate some discussion. We hope to get some feedback from yourselves. We obviously have a view on things, but we'd love to hear your perspective. This in no ways we intending to be prescriptive around this. This is really just sharing our findings and yeah, seeing how that relates to you. And in raising this awareness, we hope to assist you in managing your risks and also be better prepared when you go to court to get a settlement or an award, and that the award or settlement will be in your favor. So that's the, just before I continue, if you have a question or a comment, I want to ask you to please hold it at the end of each of these four issues or main points that we're going to discuss. I will give time for questions and comments. If you're scared that you might forget what you want to ask, just maybe type it in the comments, and then you won't forget about it. Thank you. So the first issue, and that's a big issue, and it's getting bigger, is lack of collateral. Rudman versus RAF is a case that's being quoted very often, but I think that quote is worth reading, and it's in the final analysis. An award cannot be based on speculation. It must have an evidential foundation. No, that's not the only case. There's actually many cases, and we just took a selection of cases. I'm not going to be able to go through all of them, otherwise we're going to run too late. I certainly would be happy to make the rulings available to yourselves. You can just send us an email. I'm sure you'll be able to find them online, but if there's any issues, please feel free to email us and request information or rulings afterwards. I think just maybe the top 2 or 3 in Matabula versus RAF was a farm worker. There was absolutely no collateral provided. Extensive reports, medical, industrial psychologist, the works, and the loss of earnings claim was simply being dismissed on the basis of there being no collateral. I obviously don't know what happened there, but on the balance of probabilities and looking at the detail of the information provided, this person was most likely employed at the time, and simple collateral, employer certificate, bank statements, anything that could have given the court confidence that this person was earning money would have changed the ruling probably. Nal versus RAF, same issue, and we often see that with self-employed people, cash in hand jobs, the like, that there's no or little collateral available, but again, the claim was dismissed for loss of earnings. And in ALS versus RAF, part of the earnings was for the additional earnings, there was no collateral, and that part of the claim was dismissed. And there's two quotes here that I think are worth paying attention to. In ALS versus RAF, the judge said it is unsatisfactory that experts are not provided with accurate information from which to draw their conclusions, and it is equally unsatisfactory for experts to express opinions without having the correct facts at their disposal. Excuse me. I think something that we deal with a lot as well is the informal sector in South Africa, the cash in hand type jobs. And in Slotshire versus RAF, the court certainly acknowledged the fact that there is a sizable sector in employment in South Africa, and that it is not easy to provide collateral, but yet the court ultimately ruled, and I'm going to read that sentence, however, the courts cannot turn a blind eye to the duty of the litigant, where he bears the onus to provide sufficient proof of income. In our experience, and this is also something that we've discussed with a lot of other actuaries, this is being discussed extensively in the Asset Damages Committee, is the issue of collateral. And we're looking at a hierarchy of proof. And when we talk about the hierarchy here, it really is to, in our opinion, what carries the most weight. And we certainly see that being borne out in court rulings as well. So at the lowest level is reported earnings, and now it might very well depend on the judge. But as noted, we've seen several cases where the loss of earnings claims were completely dismissed to there being no collateral, only reported earnings. And I would go as far as to say that in many of those cases, people did earn money, they were employed, but simply, make no effort being made in terms of providing collateral, resulted in all that effort being wasted. The next layer is affidavits and invoices, and I think to a large extent affidavits could cover to some extent reported earnings, where if any clients, co-workers, even neighbors or family can provide affidavits to attest to the fact that somebody has been earning money or that they were a client to that person, it at least gives credibility to the fact that they were employed and earning money, even if it's not sufficient evidence to the time determined total quantum. Invoices is also valuable. Obviously, anybody can sit behind a computer and just put together an invoice, but still it is better than nothing. Bank statements are valuable. A bank statement doesn't tell us the income, but at least again it shows that money goes into a bank account. I think that the hierarchy starts here with an employer certificate. That certainly gives us quantum to work with, and I think carries a great degree of credibility. Then we also have payslips and financial statements, and at the very top, tax certificates of forensic accountant. Forensic accountant relates to business, and I think where payslips and tax certificates especially are very valuable is that there's official documentation. It comes from a third party. SARS documentation gives you a holistic view of the person's income, and we found the courts to be generally very, the courts are ranking it quite highly. It's generally considered to be indisputable proof of earnings. The next issue we're seeing is with unsupported opinions. Lully versus RAF is again a case that we often see quoted. But baseline being that, and the judge's wording was, the statement was not supported by any further evidence or reference to academic writing or statistics. And this really specifically relates to data that's available in the public sphere, or data that should be available to professionals such as educational psychologists and industrial psychologists around earnings. Again, there's cases that we can look at, and I think specifically for Kasim et al. Versus RAF, the fifth plaintiff in that matter was 2 years old at the MBA, and it was postulated that they would have earned it in, years down the line, would have achieved a degree level of education, but no actual evidence was advanced in that regard. And I think the difficulty here is and what does the judge do? You might feel uncomfortable with the postulation, uncomfortable with an assumption, but ultimately what happened in this case is the judge ruled that the 3-year college qualification was more likely and applied 50% contingencies. Now, that is an issue that could have been avoided if certain data was cited and it was supported. In FGW versus RAF, the minor was 5 years old and progressing well in school, and the court just really kicked the can down the road there, saying, well, you can't really assess what's going to happen with this child and their career. They're doing well, everything looks fine, and it's too early, and the loss of claim was postponed. Loss of earnings claim was postponed. And this was Lully was in a number of newspapers, and that's why people are familiar with it. It was actually quite humorous in a way. A minor of 6 years old at the date of accident simply lost the front portion of their toe, and a massive claim was lodged. If I can remember correctly, it was a 5 million rand claim for loss of earnings. That was summarily dismissed by the court, and simply they didn't prove diminished lack of earnings capacity. I wouldn't say that was due to any negligence on the side of the plaintiff's experts. I really think they were taking a big fat chance there. But anyways, that was quite an interesting matter. In Safatsa versus RAF, it was quite interesting in this instance. And this is an unsupported opinion. The IP postulated that the claimant should really just quit their job and look for something different that they can do. And the judge's wording was that I'm not persuaded that the industrial psychologist's extraordinary recommendation has merit or is in the plaintiff's best interest. And in the end, the judge ruled that this had no basis and that the loss should be contingency based. I think I'm going to skip ahead. In terms of unsupported opinions, like I've mentioned earlier, the biggest lack that we're seeing is data that's available, that's not being used, or the lack of actually collating data that's relevant to certain cases. So OPSA has provided professional practice guidelines for IPs, and we think especially for your experts, the IPs that you employ, we would urge you to encourage the IPs to study the SAOPSA guidelines and employ them as far as possible. Ultimately, these guidelines will serve to give better postulations that are not really disputable and will hopefully result in quicker settlement or better judgments in your favor. And ultimately, the goal is there to provide the court with insight why a scenario is reasonable and probable. The earning sources selected should be based on background work, the work record, and then the profile of the claimant. One should consider employment trends and statistics. We very rarely see any real insight around employment statistics in South Africa, other than saying unemployment is quite high, but that only features in the injured scenarios, never in the uninjured. And also, if there's more than one scenario, that the IP should state which is the more probable scenario. This could be problematic. Sometimes it is worthwhile to consider two scenarios and calculate the earnings on both. But in most cases, we see the court looking for that more probable scenario. And to be very clear about that is valuable. For instance, within the educational psychologist and taking into consideration the matter I mentioned earlier, we've seen educational psychologist reports where it simply assumed a person would earn a degree or a diploma, but no justification is provided. Yet the Department of Higher Education released statistics in 2020 around the highest level of education attained in the working age population, aged 25 to 64. And what might be of interest here is that if we look at the highest percentage that achieves a diploma is 12.8%. Only 6.8% of working age people have a degree. So certainly if you want to postulate that somebody's going to have a degree, it needs to be cognizant of this fact that that really puts you in a small percentage of the population, and justification should be provided. If judges wakes up to these statistics and the justification isn't provided, we should surely expect the judges to go, well, these postulations are not backed, and take a dismissive attitude towards them. And something that's maybe quite shocking, but it's unfortunate, is the median position in South Africa for a working age person is actually less than grade 12, which means if nothing is known of a person, your assumption should be that they achieve less than grade 12. That certainly is not something we see in postulations, and we hope that you know, people have better prospects, and that those better prospects will play out. But the purely data-based approach is going to make one aware to make effort to gain proper justification for any postulation of achievement or educational achievement. In terms of outdated information, we've now bumped into a couple of cases where there were rulings where outdated information really had an impact on the damages awarded. In ZN versus RAF, the expert reports were outdated. I think IP reports are typically valid for 2 years. And the judge took a view that these outdated expert reports, you know, does not stand to be relevant evidence, and there was interim payment made. The final award was postponed in that matter. In Quincy versus RAF, there's a couple of issues. The one was no proof of earnings, which is obviously problematic, but also the outdated IP report, the claim was dismissed. And in Kasim et al., the IP information was outdated. So at the time, the industrial psychologist worked from the basis that the claimant was unemployed. Factually, the court established that they were actually employed at that time, and that changed the whole basis of the postulation. The judge also noted that the IP report may have influenced other expert conclusions, including the actuary, of course, and the future loss was dismissed. So it is really in your favor to keep your experts updated around what's happening with the claimant. And I think specifically, you know, with regards to employment status, any changes since the IP report or other expert reports should be considered and taken into account, and if necessary, updated expert reports should be sourced. We are often asked to update or amend an actuarial report. We're obviously always quite happy to do that, but at the very least, and especially in cases where somebody was employed, we need updated earnings information. We need update on the employment status. For children, it might really be worthwhile to consider any achievement of milestones. For instance, in an injured scenario, it might be postulated that the child will only get to grade 10, and at the time of the update, they might already be in grade 11. That invalidates the previous postulation or assumption, and the whole situation that needs to be reassessed. In Twine versus Nido, the court ruled, or stated the responsibilities of the expert, and that is not to omit any material facts. And we need to be aware of the material facts and adjust our reports accordingly. When you request an update or an amendment, please consider whether the expert reports are still valid. If they are not valid, I would really recommend looking at getting an update, unless you know that the change is immaterial. But any material changes, I think it's worthwhile to get an update. If the expert reports are still valid, please just consider if there's any change in the person's employment status or earnings information that will help us to give you a more updated, more relevant actuarial calculation. And ultimately, making the effort to ensure information is updated will reduce the risk of names being dismissed or arbitrarily being reduced by judges. This should work in your favor. I do apologize for drinking a lot of water. I, up until recently, had an 8-week bronchitis, and my vocal cords hasn't completely recovered yet. Thanks for bearing with me. The last issue we're seeing is the unestablished causal link. And that's interesting. I think the injury of the 6 foot, or the toe injury, not resulting in 5 million rands of damages is quite an obvious one. But in Yasin versus Raf, I think the quote is worthwhile. There is no other evidence before this court to prove that link other than the plaintiffs say so. And I'm sure those of you who are experienced with court matters say so just doesn't carry much water in court. My wife certainly thinks, say so does carry a lot of water. If she says so, I do that. Judges are unfortunately a little bit harder to persuade. WPM versus RAF, government employee, they resigned their job. They said it was because of the injuries of the accident, but there was not enough of a causal link established. It was quite flimsy, and ultimately the court ruled and said, well, this, I think it was a 5-year period that elapsed. They weren't placed on light duty. They basically were able to continue their work and then resigned. The court said, well, you can't now suddenly claim it's the accident, and that claim was completely dismissed. In Yasin versus Raf, the person's earnings only decreased years after the accident. The injuries was healed. This person had orthopedic injuries. Their job was mostly a white-collar job, cognitive job, and the court ruled that there isn't a causal link. There was all sorts of other reasons why the earnings could have decreased. And again, I don't think one could just dismiss for myself out of hand that the decrease in earnings wasn't related to the accident. We know there's a lot of degenerative injuries that only show up later in life, but the fact remains a proper causal link wasn't established. The court had nothing to go on except the fact that earnings have decreased, but there could have been any number of reasons for that. And the claim was dismissed ultimately. So in conclusion, in terms of these 4 areas that we've mentioned, we think it's worthwhile for our clients and for the plaintiffs to pay attention to these matters to reduce the risk of claims being dismissed, but also to enhance the probability of settlement or receiving a favorable judgment. So please, in all instances, provide collateral. Ensure the earnings postulations are reasonable and can statistically be justified. And that is in particular for the industrial psychologists. Like I said, we really think industrials will benefit from the SAOPSA guidelines to provide watertight reports on which we can confidently base our calculations. When there's a delay or amendments being done, please provide updated earnings information and reports where relevant. Phone our office. I'd be very happy to discuss this or answer any questions you might have.